Good evening, Ritu ma'am. Welcome. Hello. Ritu ma'am, are you there? Pujalakshmi, Gaurav, am I audible? Thank you. Pujalakshmi, Gaurav, Ritu ma'am. Ritu ma'am, okay. Ma'am, are you able to unmute yourself? Yes, ma'am. Good evening, madam. Welcome, ma'am. Madam, you are not audible, ma'am. Pujalakshmi, Gaurav.
Yes, sir. I hope I'm audible.
Yes, you are audible. Yeah. There's a issue with, I'm sure ma'am, I think will be joining soon. There's audio issue.
Ma'am, you're not audible.
Yes, ma'am, are you able to unmute yourself? Yeah. No, madam, you are not audible. No, 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 no. मैडम आपकी आवाज नहीं आ रही, सॉरी वहां से.
Ma'am, can you try rejoining? Maybe it would help.
आई थिंक मैम ज्वाइन रीजॉइंड. हेलो. यस मैम, आर यू एबल टू स्पीक? हेलो. मैडम मोबाइल से ट्राई कर रहे हैं या 1 सेकंड. मैं रिक्वेस्ट सेंड किया है मैंने मोबाइल पे.
Hello, can you hear me now? Can you hear me now?
यस 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 मैम, यस मैम.
Yes.
मैडम एक आप बंद कर दीजिए, 1 सेकंड.
Is it okay?
ओके मैडम, फिर ट्राई करिए ना एक बार. ओके. अगेन. 1 सेकंड मैम. यस मैडम, प्लीज ट्राई.
Hi and good evening to everyone. I think I'll have to.
मैडम आप लैपटॉप यूज कर रहे हैं तो लैपटॉप में बंद करना पड़ेगा, तो मोबाइल से यूज करिए क्योंकि डबल आवाज आ रही है। यस मैडम, अभी ट्राई करिए आप। वन सेकंड।
Am I audible now?
यस मैडम, अभी सही है।
All right. So I'm sending my PPT to you. Please
Okay.
share it.
हाँ भेजिए मैम, श्योर।
Right. I'll just forward.
ओके मैम, थैंक यू।
Done. Please check. Yeah, very good evening to all the participants of this PPT. Can you hear me?
यस सर, गुड इवनिंग मैम। पीपीटी दिख रही है मैम? गौरव, विजयलक्ष्मी।
Yes, sir. Yes, sir.
Yes, sir, it's visible.
यस मैम। ने सर्विस स्टार्ट। रितु मैम, सर्विस स्टार्ट।
Can you hear me?
यस मैम, आई होप आई एम ऑडिबल।
All right. So,
ओके, सर्विस स्टार्ट मैम।
no, I'm not able to hear you.
हेलो।
All right. Anyways, I'm so sorry for the delay, but let's start the discussion for the day.
वन सेकंड।
And thank you so much for your
Ma'am.
patience and the
Ma'am.
inputs. I'm getting the messages. So first of all, let me congratulate you, the organizers, especially Dr. Kalpesh, who thought of this idea of organizing this kind of innovative FDP. This particular FDP, I was very interested because what was happening that talking about the skill sets of teaching different law papers, that in itself was such an interesting concept. And the way it has been taken up, and I have been seeing the reviews. So that's really wonderful. And now I hope with today's discussion, somewhere I'll be able to contribute to the existing knowledge to all the wonderful participants. Yeah. So as I have no this is should have pretty good idea that so actually I'm so sorry this technique that with the system, with the link, I don't know, but still, when we talk about this particular subject, so this interpretation as yeah, I hope I'll be better audible now. I have switched off my camera. Yeah. So as far as this interpretation is concerned, when we say that separation of power is there, if we talk in terms of our constitution, when we talk about the constitution has provided something about rule of law, and we talk in terms of separation of powers between the legislature, executive, and the judiciary. So this is the point, a very important juncture in the life of a law student, that how do you actually try to interpret what was there in the minds of the legislature, and whatever gaps are there, whatever voids in the words which have been written by the persons who have created that particular statute. So this is an art. So just like any painter works with its tools, paint and brush, or there are like musician who works with different types of musical instruments. In the same way, we as law teachers need to talk about the tools that are being used by the judiciary in finding it out, in giving it a meaning, and how far the judiciary is free to, give that meaning. So this is what is the most important thing. And this is the art. That's why I have mentioned it in my slide also, that this is the art of finding true sense of words expressed in the statute. And sometimes what happens? We need to differentiate between interpretation and construction. On the face of it, interpretation as well as construction appears to be the same. So anybody would like to make any attempt, you can just use the chat box and just mention if you have this idea that how do these differ, interpretation and construction, that I'll take up in the next slide. Yeah, please switch on to the next slide. Yeah. So this is very interesting. What I thought is kind of a circle, because why do we need interpretation? So what happens? Through interpretation, what we develop is understanding, and through understanding, what we get is appreciation of, when we talk in terms of statute, so who had created that statute, so we are able to appreciate. And once you appreciate, that automatically provides protection to those words which have been crafted. This is very interesting. Again, every time whenever I teach this course, and especially when I address to fifth year students, So there is a special bond between the teacher and the student, and the way we interpret and the way we find out how the judges have taken pains to, so how long we are able to contribute to the knowledge of the future lawyers or judges or practitioners or whatever you may term as. These days we call them as partners in various firms, law researchers. So this is something which makes it very interesting. So this is where I think we can pause and we can just go on to the next slide, because this is the Tilden's principle that we just did, because as I told you, we are just going to touch upon certain things. So since we are talking about interpretation on the one hand and interpretation and statute is on the other hand of the subject, but without statute, there cannot be any interpretation. So since law calls it as law, we sometimes broadly we call everything as law. We may term it as act or enactment. So there we include every type of ordinance, order, bylaws, rules, regulations, and whatever circulars are being issued from time to time. But how far those statutes are prone to, be interpreted differently than the way that was envisaged. So written will of the legislature is provided in the statute. So this is that written will that is provided in the statute, and now learning the tools here, we are going to interpret it. Yeah, I'll just have a look at the responses, and I see Dr. Shobha Rani has mentioned that interpretation refers to understanding of the words, whereas construction refers to drawing of the conclusions. Yeah, very true and very correct. And Mr. Gaurav has mentioned that interpretation precedes construction. So that's also, if I put it in funny terms, it is a Tom and Jerry situation, but not hen and chicken situation. Because ultimately, what precedes another, or whether sometimes they coincide. If you read in the literature, there are various jurists, and I didn't try to bombard you with those languages which have been used by the jurists, but various jurists have said that interpretation and construction, they overlap, and there is as such no difference between interpretation and construction. So construction is just like construction of building also, right? But construction of statute, how come it's different from construction of statute? This is again one interesting aspect. And I see Vani has written that interpretation is reading between the lines. Interesting. But really, do we need to read between the lines, or we need to connect the dots? Vani, I would like to have your some further more words from your side to explain this. But yeah, can we have the next slide? I'm so sorry for this inconvenience today. So this statute is a declaration of the law as it exists, or as it shall be from the time at which such statute is to take an effect. And that's why every time we have been talking in terms of that it is a collective will of the body. So statute, just like body, has got different parts, and sometimes that enactment may mean something other than an act of parliament. And trust me, and I feel that on certain points you'll agree with me. If it has to be Honorable Chief Justice of India, Justice Chandrachud, if it has to be the former Chief Justice, if it has to be any other Honorable Chief Justice, Honorable Judge of the Supreme Court, or the judges of the high courts. So there you will see the variation, and somewhere this interpretation leads to what you term as judicial process, because interpretation becomes an important component of the judicial process, because ultimately it's the judge who has to give effect to what legislature had in its mind. So I hope that this is one thing which I thought that I can't teach anything to the teachers and the trainers, but this juncture where we can discuss all these points. Yes, I'm very happy. Sambita has mentioned that it is to find out the intention of the legislature. I'm very happy, sententia legis, because it's already there. Even you'll see this. Can we have the next slide, please? So in the next slide also, next when I say in the future slides, because I myself cannot just scroll it. So please bear with me the kind of inconvenience that is happening. No, just go back to the last one. We'll come back. When we say act means the whole act, and enactment sometimes refers to part of a section in any act. So what I expect of this body of the teachers who are present here, participating in this FDP, and who are, eager to learn, to them my humble request is to spend as much time as possible with your, we call it as normally target audience, or we call it as the, very senior students. And there, if you ask them that difference between all these, what we have just mentioned, so they be a very great contribution. They know what is corporate law, they know what is criminal law, they know that what is jurisprudence. But when it comes to putting all of these together and finding it out, so that is the point where you need to hit. When you touch upon this soft point, that is where the your actual hard work will bring fruit. Yeah, Gaurav has mentioned that to decipher vague and ambiguous legislation. Absolutely right, Gaurav. So these are a couple of the inputs that we have received, but it's very, very interesting thing, and we can devise few more interesting manners to make it rather more participative in nature in your class. Next slide, please. Yeah, so this is what you have also mentioned, and here I am also trying to come to the same point, because what is important, I just thought that I'll talk about few judgments also, but before that I'll take some more time in taking you to the same page where I am when I am talking to you on this. Understanding of the words and the true sense of a legal text. So text and the context, these are two things that become relevant here. And here, because as we just saw that many of the participants have mentioned that drawing of conclusions of the legal text that lie beyond the direct expression of the legal text. So this is where we use this construction, and somewhere it's slightly similar to construction of the building, because here also what legislature did, they also tried to construct and edifice. And this is the edifice that we need to take to our edifice. Sorry. And this is a edifice that we need to take to our students. Next slide, please. Yeah. So just see, though I avoided so many jurists, naming those jurists, because I'm very sure all of you have read that. And I just don't want to be repetitive in this lecture, because I'm seeing your patience for last close to 1 month. But I couldn't resist when I read Friedman, when he says no living thing can have its organs offset against each other as checks and live. Because what happens, see, very interesting. And daily we see this. But when it comes to teaching, sometimes there is a tendency that we just skip through. That the life of the different organs of anybody is dependent upon the quick cooperation, the ready response to the commands of what you term as instinct or intelligence, their amicable community of purpose, their cooperation is indispensable, and their warfare is fatal for anybody. So this one quote keeps me going when it becomes too retarding, when it becomes too complex. So that is where you can really look into the relevance of what actually this one is. Yeah. So, all right. So can we have the next slide? And I'm very sorry, Pooja, you had written text about my introduction. I think at the end of this session, we'll try to do that, because earlier I didn't, I just couldn't because of that technical glitch. And here I'll bring the attention of all the participants to various rules. Literal rule, liberal rule. I'm very sure Hayden's rule, that mischief rule we have been calling it as, or golden rule. In my understanding, all the rules are actually golden rule. That doesn't make literal rule golden rule. But when I say golden, there I am using golden as an adjective, because all the rules are so important and so beautiful. It's the only thing we have to see how the judge has come to that particular conclusion using that tool. When I use chisel, when I use scale, when I use some different instrument. So that is the point. Where do I need to gauge and measure? So these are the points that I really understand, that I'm not going to detail these rules, but we have to see that the basic objective is to mend, is to not to amend. Basic rule is to interpret, not to, just change what was desired at the time. And one very interesting question will come to your mind also, and I'm very sure so many times you might have got this question. Why, what makes 1872 law of contract so relevant, or 1882 property law, or if I'm 1860 criminal law, though we have certain amendments to this, but still they are going on just because the judiciary has been there to resolve that conflict whatsoever has arisen in the while construing or bringing the meaning. And this is again very interesting for us to see. Please have the next slide. Very quickly, I'll just finish through my slides and then we'll discuss more. Why I am talking about this particular reflective, what makes me say so that the process of interpretation is reflective. Again, I would like to have your viewpoints on this. My question to you, I just need your ideas to make it rather more participative in nature, that what makes this process of interpretation as reflective, and the various rules of interpretation, when I say just help in this reflection, and nowhere they mean to substitute. This is the crux that we need to fine tune. And how do we fine tune? That's again not whim of anybody. That cannot be. What is reasonability? So that reasonability, again, we have to gauge. What is a presumption? What is a legal fiction? Whether it is what John Grisham has been doing, or legal fiction is something more. Whenever we talk about, whenever I agree to one style of interpretation, then again something counter appears. What is that something counter? And what makes that counter approach more appealing at certain point of time? So that certain point of time is something that I need to further refine and define. So this process of refinement and this definition, these are the things that really would work as a tool when you want to teach this subject to Gen Z. I'm sure that the kind of challenge I have been facing at National Law University, Delhi, all of you must be feeling at your respective law schools, because this generation refuses to accept the interpretation as it is. I'm very happy that Vani has again taken care in she's very specific in defining. We basically look into history as to what was the intention of the lawmaker. But again, Vani, this is for you and for all the participants, that the time when it was 1872, the intention of the legislature was never to address the contracts that are made through WhatsApp or through what you term these days as electronic world, cyber contract, or so many more approaches. And Gopika has again very interestingly mentioned the idea is to get the legislation's intention at the time of drafting, and that's why it's reflection. Yes, that is. But how do we travel back? So that only happens in movies, but not in the real world. If you are to talk in terms of Keshavananda Bharati or any other, all those 10 to 15 classic judgments that we have been always talking about, and Harsha is mentioning, we focus on why and how part while dealing with legal issues. But what about while finding out the true meaning of the very catchy words, when those have been very cleverly inserted by the legislature? And yes, when you mentioned, Vani, that we just adjust that to current scenario, but is it just like adjusting the seat of the car to your heights? No, it is not. Or it is like sometimes when legislature drafts, it's just like Tesla, unmanned car. You have something which you thought that is going to follow. But what if it does not follow? So I'm not talking in terms of AI. I'm just saying that whatever someone else had done century ago, what makes them so relevant, and of course, very right, Dr. Ragini, I'm very happy that you have been able to crack that too, that legal fictions can be used. Absolutely correct. So I'm very happy. And once again, Dr. Kalpesh has done this wonderful job along with his team of organizers and seniors, that the participants are so eager to even mention, like Sangeeta just mentions, and it's very interesting. See, this is what I had said and what I really meant, that we learn from each other. So when you are talking about, sometimes it is very difficult to teach the postal rule because this generation doesn't understand postal rule for offer and acceptance. But see, that stands test of the time. But again, whenever the need be, even I would like to suggest some changes therein. That's interesting. And at some platform, but still till the time those things actually take shape, we need to work just like that. And the Gopika has mentioned that we look into the legislative discussion happening while the bill became an act. But that discussion, Gopika, once again, I'll just come back to you on this point. What is the applicability of that discussion which took place? Sometimes, whenever we need to interpret, we might use it. But I don't know whether we actually mean to do that. And like, if you can see this slide, the last one, it says, last point in this slide, multiple rules required for interpretation to be an honest and holistic exercise between the text and the factual situation. This is again something very important for all of us. And if I say, when we are talking in terms of multiple rules, so all those rules which have been there or something more. When Supreme Court says that gender issues, when you talk in terms of triple talaq, when you talk in terms of all those gender sensitive judgments, so one has to travel an extra mile while talking about same-sex marriages, while talking about UCC, though it hasn't come into force, but still what you see that those issues, because here let's come back to text and context, because what will happen, that situation like is just like again, one interesting thing I would like to share with you is public policy. So the same way public policy doesn't remain constant, and so is the situation with the interpretation. So every time judge will have to travel that extra mile to interpret that particular law to the context in which it has arisen. Can we have the next slide, please? Yeah. So again, as I told you, because these jurists, they are unavoidable. Even so hard I did try that, let's not make it very heavy and let it be a very simple discussion, but still it is something which really fascinated. Sometimes they insist literal is the safest one. Sometimes you need that extrinsic evidence also, right? Sometimes you're talking about in terms of procedure. Sometimes you look at the committee reports. Sometimes the interpretation is being done by the administrative officials who do not bother about law and who are not that way trained in law. And sometimes when the judge becomes so what is the role of that judge and how far the judgments of those judges really. So this is what you see, and I just need to flag these issues. I just want to have that flame that makes it such an important paper. But I think that when we teach, we have to be very, very sensitive to with our students. Generally, as a teacher, we are. But when you talk about this paper, which is very, very vast, sometimes we may call it as vague, it is something like abstract thing, because it's very difficult for them to understand. Like here, I have just mentioned, you just read about all these things. Lord Coke's mischief rule to be the cornerstone and everlasting guide to interpretation of statutes. What makes it that way? मेरे स्टूडेंट बोलते हैं, मैम आप ऐसे ही बोल देते हो कि मिस्चीफ रूल, हिडन रूल इस केस में ऐसे डिसाइड हुआ और उस जज ने ऐसे इंटरप्रेट किया. I don't agree. See, but the point is, even if we do not agree, but that is again, as I just mentioned you, that's an important thing when you talk in terms of judicial process. Cardozo, so beautifully, Cardozo, while describing this process of the judicial process, what is the background of the judge, how conservative or open-minded the judge is, and what has undergone or what he has undergone before talking about this. Yeah, so this is very interesting. So very quickly, we'll just have this. Yeah, very, very right when Dr. Kalpesh, Dr. Kama Sevam, when you are talking about is it desirable to have, please complete your question so that I just understand it further. Meanwhile, yeah, and just forgive me, we just might not relate to the structure which is there, but I intentionally put it here. Why? Because there are certain concepts which are so important to us: basic structure, judicial review. We are talking about the exclusivity of the legislature in making the law. But very rarely we talk about the role of judges. And when the judge steps out of the boundary, who is going to find out or decide whether that stepping out of the Lakshman Rekha was correct or not? And what we say every time, we have been reading in jurisprudence, Austin and Kelson Pure, where you say we talk in terms of rights and duties. So what is the duty of the court? How do we take it to the students who just know that judges are powerful, that lawyers lie, lawyers are the officers of the court, but they sometimes are swayed by either power or any other point has mentioned that is it desirable to have common of interpretation? Yes, I agree. Though I just don't have a choice. But this is where we need to see that to have common rules of interpretation. See, let's try one thing. And this one example you can always use that teaching. We have been talking about ChatGPT. We are living in the age of machine learning and AI. Why are we not, in some countries, even that experiment has been taken also. But why we don't talk in terms of robots as judges? And that is what, that variation, that difference, that brings beauty in the judgments. That are empowered by the Constitution for the judicial review, and they have been doing it. They can just reform. So current judge, the honorable lordships are empowered to change what was the law till then. All of us agree with that Vishakha thing, right? Because what was not there, and Justice Verma with his fellow brotherly judges and sisterly judges could bring that to foray. And what is the role of international law? So this is what there, when I have mentioned it here, in acknowledgement of legislative primacy, court issues a caveat along with its law-making activity. And that settles the, boundaries, or that draws, or that underlines. Yeah, can we have the next slide, please? Yeah. So again, see here that sententia legis that our participants, they had already put in this sententia legis. If I go, yes, Sambita was there when she mentioned. So Selman also talks in terms of essence of law lies in its spirit. But what about the black letter of law? And what if that black letter actually legislature wanted to write with red pen, red ink, I should say? Means wanted to tell you that no, you can't cross this, that just like red light. So that's why that letter, black letter, or that red letter, I might say this, is external manifestation of the intention that underlies it. And that's why where the role of litera legis, that the courts must accept. This is very interesting, and I am not going to detail, but just flag ita scriptum est. So read this, and I'm sure that you know about this better than, you understand it better than what I do, but still you take it up with your students, and I'm very sure they will get back to you on this. Yeah. Next slide, please, because I think Dr. Kalpeshwar, how much more time do I have? This was very interesting one. I really find it very interesting. Renaissance Hotel Holdings, INC versus B. Vijaya Sai. And this is 22 judgment of Supreme Court. And Supreme Court reiterated what was laid in 1987, this peerless case, because this Reserve Bank of India versus Peerless General Finance and Investment Company is one of the classic cases of interpretation. And very interestingly, so many things have been there, but here the Supreme Court explained the rule of interpretation. Please have the next slide. While reiterating, Supreme Court just mentioned that it is the straight law that while interpreting the provisions of a statute, it is necessary that the textual interpretation should be matched with the contextual one. So whenever you discuss any judgment, any penal statute, any tax related statute, why should we have GST? Why should we have that particular law? Why should we have amending section? Why should we think in terms of repealing a law? What is this comma? What is this full stop? And that's exactly where the courts have said that the act must be looked as a whole and that it must be discovered what each section, each clause, each phrase, and I'm talking about 2022, when the courts have been using this and designed to say as to fit into the scheme of the entire act. These days, what is the tendency? In the days of social media, 24/7 news media, what have we been doing? Just picking up. You just pick up a particular page from a diary. You pick up just one line from a particular statute, or just pick the obiter. I'll come to this interesting aspect also. And we are so fascinated by the obiter that we forget what majority has said, or other way. We are so fascinated by the majority opinion that we forget that what is there in the obiter. And this is where we need to have a balance, because the courts have been reiterating, even at the cost of sounding conservative, that no part of a statute and no word of a statute can be construed in isolation. In isolation, things get really worse, because what is, again, we come back to the intention of the drafters, and that is where we have to see stand alone. If we talk in terms of the and all those state lists and union lists and concurrent lists, does that make any sense? But talking about those lists with reference to or with in context of any particular law that has been drafted, and that law didn't come because somebody had whims to bring that. So this is what we need to see, that statutes have to be construed so that every word has a place, and very interestingly, everything is in its place. So it's just like overhauling your wardrobe every time and then keeping it back in order, so that your dress or whatever you are trying to get makes sense, and you need to remove those portions which do not make sense or which become obsolete. And that's where an amending act. So this is where we bring in that what can be construed. Like so many times we have seen that the courts have been very, very liberal when they are say interpreting any, say, standard form contract, which they usually interpret in favor of the weaker party. It is not that weaker party is not at fault, but the point is, in case of ambiguity only, what you term as contra preferentiam. See, when we were students, contra preferentiam, we didn't talk much. But today, that contra preferentiam has gained importance. Consumer protection laws have gained importance. Competition law, what you term as umbrella legislation, is really very important. Public policy has become important. And that is where, in today's context, things have really changed. So this is where we need to understand how do we take the content to our readers or to our students, so that whenever they sit in the bench or whenever they argue before the bench or whenever they teach the next generation of lawyers and the judges, then they know actually how to use that particular tool which has been in existence. Yeah, can we have the next slide, please? Yes, this is where I thought, this is about my thoughts on the obiter. And because when you teach interpretation, so you have to talk about ratio decidendi, you have to talk about the obiter dictum also. So whether the obiter of the Supreme Court and the High Courts are binding. Again, you have multiple, answers to this. No single answer will work. And whatever I have mentioned in these slides, that's only what I think that we could have discussed. But interpretation is still beyond this. Interpretation is something more than what we have been able to actually flag today. Because I hope Justice Pushpa Ganediwala's judgment, skin to skin contact. Whether I criticize the judgment or I criticize the judge, or I criticize the judgment more because the judge happens to be a woman. So are we trying to impart a gender to the judgment writer? These are, usually we have been progressing towards gender neutrality. But when it comes back to any kind of judgment, then we become very, there we talk in terms of binary of the gender, right? So these kinds of dichotomies, these kinds of paradoxes, they have been coming with us, just like covenant running with the land, right? So this is where one has to be very, very clear that this generation of students, they are not going to be satisfied with very, very simple things which have been very established, but they are in the habit of questioning. Plenty of the material is available at their fingertip, but whether actually they draw something out of learning too much on that particular subject. And the third point in this obiter, I just thought that I'll talk to you is whether there is a need to raise issues with respect to moralizing obiter dictums, because this is in special reference to the observations which have been made or the remarks made by the court, saying something to the victim of a particular sexual violence, but that was just a by the way remark, or telling something to a student, by the way remark. So whether when we are talking about moralizing these obiter dictums, considering their persuasive influence, this is what we need to understand. The next slide, please. Yeah. So, and again, this is what I really liked, and that's why I thought of sharing this with you, though old one, but still, because in this Mera Dev Authority versus Association of Management, it has been stated that judges cannot and should not impose their will or their values on the society. Their judgments should not comprise of what they think is moral or right. So again, we do not usually question, but this is the time when we really question and when we respond to the questions of the students pertaining to these particular aspects. And here at this juncture, I'll just take what Dr. Shailendra Gupta has mentioned, that how far this ideology of an interpreter decides final outcome of interpretation. Yeah, I'm also at bay like you. So, sir, even I don't have an answer. How far you agree with the statement that law is nothing but politics? It's not the question of agreement or disagreement, but the point is, this has been stated by various jurists when we talk in jurisprudence, political will. So how far that political will decides the fate of the objectives of any statute, is that really makes I think that is the what will provide answer to your question. So most of the time we know this. Who appointed the judge? The judge had belonging to which party or to which particular side of the part. One, when I say party, is political party, and second party when I say whether he was the plaintiff or the defendant. So all these issues, and from which background does the judge come? So in the as Cardozo has mentioned, brewing of justice. So that is what you have to see. It's not just like any CCD or any Starbucks where they brew coffee, but in the corridors of the courts, especially the appellate courts, that justice is being brewed, and how we actually, which all principles do we apply? That's what we need to. And I'm very happy with the participation. And here, Dr. Oriongo, who has mentioned that a particular scholar has called law politics in another guise. Whatever, see, because the scholars are free to say whatever they feel. But the point is, we cannot have any judgment pure, because there may be, it is not that that makes all the judgments impure, but I simply wish to say that there are certain external factors, because here we are discussing interpretation of the statute, and here we are not talking about the external pressures or external whims or external stresses that might be there on the head of the judge when he or she is writing that particular judgment. So I just didn't understand, Dr. Kamasevan, when you say it is will of the Constitution. Yeah, that's very agree, but that's very right. Will of the Constitution is perfectly fine, but how that will is interpreted, that is what I'm trying to discuss. And Dr. Garud has asked my thoughts in Sabrimala decision. So here female judge gives dissenting judgment. Very right. That's why, Dr. Garud, I simply pointed out, why are we looking at the gender or the sex of the judge? Why can't we think like a teacher, if teaches interpretation of law, then whether we look at whether the judge who is teaching is a male or female or from any other gender. This is what is very important for us. When we see our students as neutral, and in the same way, when we are teaching, so we should not mix that with my own ideology. But can I actually keep my discussion separate from my ideology is a very, very difficult question. And I think for that, once again, we can do some brainstorming, and I'll request Dr. Kalpesh that on some other platform, all of us can be connected, and there we can just talk about all these issues. But my task today was just to flag and look into, see the introspections, whatever reflections I had to make while teaching this paper. And I'm very sure those who have taught these courses will agree that without interpretation, actual execution of any statute or any law is difficult. So both are complementary to each other, right? So this is what we need to, and please have the next slide, which will simply thank you. So I'm very thankful to the audience for making it very, very lively session. And I'm very, very sorry for the technical glitches that happened at my end. I can switch on my video if my net will allow. I couldn't see, I was traveling and I was just rushed home for this. So if I have missed onto something, please have my mail ID and we can just add to this whenever we meet next. So over to you, Dr. Kalpesh, but I can't hear. So you will have to just write. I can read your messages, but I can't hear you.
Okay, okay. Sure, ma'am.
Maybe some technical problem with my web.
Okay, ma'am.
Uh,
Participant.
because I'm on campus, so might be they have blocked something because this happened. I'm not sure.
Okay, ma'am. A participant, you can drop question in the chat
So
box.
please write, and meanwhile, Dr. Kalpesh, you can read it out because you wanted to read the introduction part. So briefly, we can.
Puja Lakshmi, are you there? Gaurav? Hello.
Yes, sir. Yes, sir.
Please, you can give a brief introduction of ma'am, and then we can take up questions. Yeah, over to you.
Yeah, I think I can hear you now somehow.
Okay, ma'am. आवाज आ रही मैम?
I can hear you.
Okay, okay. Over to you, Gaurav. Will please
Volume
introduce
is
ma'am.
very, very less.
Yes, Gaurav, over to you. Please introduce ma'am, and then we'll take up the question. Yeah. Over to you, Gaurav.
Okay, sir. So now I would like to give a brief introduction of our guest. Professor Dr. Ritu Gupta is a professor of law at National Law University Delhi and has got teaching experience of around 21 years. She is a research director of Center for Business and Financial Laws at NLU Delhi. Prior to joining NLU Delhi, she has taught in University's School of Law and Legal Studies and also WIPS Pitampura affiliated to IP University. Professor Gupta specializes in commercial and business laws like law of contract, banking law, property law, and competition law. Her areas of interest include legal education and research, judicial process, interpretation of statutes, and gender justice. She has also written 2 books on sexual harassment at workplace and other on law and contract, including Specific Relief Act published by LexisNexis. Professor Gupta is an external expert member of Internal Complaints Committee of the Cabinet Secretariat at Rashtrapati Bhavan, New Delhi. Earlier, she has been in the external expert member of ICC at Prasar Bharati and Ministry of Women and Child Development, Government of India. She is also holding the position of policy advisor at NLU Delhi, advising the university on various issues related to prohibition, prevention, regulation of workplace sexual harassment. Professor Gupta has vast experience of being a resource person and has conducted training programs or workshops on gender sensitization and sexual harassment of women at workplace and contract management for judges, IRS, IRS officers, probationers, Doordarshan and All India Radio, etc. She has presented papers and attended academic events in various countries like Norway, Poland, Singapore, Australia, USA, Sri Lanka, etc. She is a member of National Human Rights Core Group of Women, Board of Referees of many referee journals, including the National Crime Record Bureau Journal, and an external expert in the advisory board of NHRC's Hindi magazine, Nai Dishaएं. She has reviewed manuscripts for Word Development, Elsevier and Sage, etc. She is a member of Executive Committee of NLU Sonipat and NLU Delhi. She has been conferred by Rex Karamveer Global Fellowship and Karamveer Chakra Award in March 2015 for her outstanding contribution to women empowerment. She had earlier been selected for the award of doctoral fellowship by ICSSR New Delhi and declared Miss Super Brain Super Personality by Competition Success Review in a national level competition in 1998. So we welcome you, ma'am. Thank you.
Yeah, thank you so much.
We can okay, ma'am. We'll take up the question, ma'am. Are you able to hear me, ma'am? Hello.
Hello.
Yes, ma'am. Are you able to hear me?
Yes, yes, I can hear.
Okay, ma'am. So, participant, you can raise your hand. You can, I will unmute you, or by the time you can drop the
Okay.
question in the chat box. There's a question in from Vani. When a court decides a case, but the state is not enforcing the same, it can be perceived from Sabrimala case. Also, what can be interpreted in in that particular case?
Yeah. Question, Bani. When you are talking about, this is just kind of, if you talk in terms of writs, so this would fall within the ambit of one of those writs. So when you are talking about Sabrimala, see, because Sabrimala is slightly a different uh, context. So this is where you have to see whenever the sentiments are attached. So there the courts cannot take the same stand they can do in, it's, say if it is a matter of construction of a road or a building, so it might be different from talking about same-sex marriage or Sabrimala. So this is, you need to use the right kind of skill sets, and that none of the rules are going to work. Rather, it is it would be very what they. So this is where, since that is a kind of very sensitive thing, and there are something which happen uh, in those points of time. So this is what we have to see. And yeah, any other
Okay.
question?
Yes, ma'am. Any other question is from Sandra sir. This is now a well-known fact that most of our basic legislation were made by the Britisher with a colonial mindset. How far it would be in the interest of justice to still go with the literal rule of interpretation?
Yeah. So, Dr. Gupta, when we are talking about justice, see, justice is a very abstract concept. So sometimes we are just swayed by that because they have been made by Britishers. That doesn't make them that. It's just like so many buildings have been constructed by them, but we cannot deny that they are beautiful work of art. Similarly, those legislations are beautifully crafted and rather better than our own legislation sometimes. So that's why this is very important that we keep them, not only we keep them, but rather whenever desirable, we carry out certain corrections if the need be, only then. So it is not about uh, being disinterested in justice if we are still following them, right? So literal interpretation nahi hai. Sometimes if the need be, then you can use the mischief rule. So all the rules here are open to you, right? Yeah. Any other question?
Madam, how do we conduct the assessment, evaluation, assessment, continuous, midterm, final exams? What kind of question we should ask, and the assessment, evaluation, what you do, and what should other faculty should do?
For interpretation?
Yes, ma'am. Yes, in this subject, how to do evaluation in that particular iOS subject.
Yeah. So iOS, we structure it like we are very. Sometimes we give them team projects. So team projects, we assign tasks to say it is a team of 3 students. So we'll assign a task, a topic to 3 students, but they have to work on different cases pertaining to that. So, and they will be assessed on the basis of their work. But the teamwork would relate to the generalization of the concept, but specifically they will have to. And along with the classic cases, it is not that you will still talk about 1950s or 60s cases. So not older than last 5 years. So you need to bring in 2 judgments at least by the apex court or by the high court on any relevant theme. And then we give an analysis. And that analysis, there are different parts. And we make them present that in the class also. So the marks for class presentation. And at the end, we conduct Viva also. So cumulative assessment we have been doing for this paper, then theory and project component, that remains just like any other paper. So this is how we go. Yes.
Okay, ma'am.
Over
And then what about,
to
madam?
you, Dr.
Yes, ma'am.
Yeah.
What about the examination questions? So, what kind of question do you ask? Yeah. Because
That's
this is,
like So we have sometimes been talking, the same, you have been asking question to me, Sabrimala. So somewhere we talk in terms of whatever new has come up. So we just want their viewpoint, like if they would have been judges in that case, how would you determine? Or sometimes if it is about liability or granting bail. So how far discretion is important, right? So Shraddha murder case or any other murder case. So this is where we take help of, I invite many of my colleagues who teach different subjects, like say one is teaching international law, one is teaching say criminal law, one is teaching political theory. So they will have their own understanding of the concepts and how to interpret international provisions, say treaties or any other convention, or if we are talking about say United Nations principles or any act, or if it is say IPC or to say any other, so or text law, so then I'll invite our text person. So this is how we usually bring others into picture. Then we invite certain lawyers, so they talk in terms of pleadings for that particular decision, how courts could arrive at that decision, and we have been evaluating them. I hope that will help. Yeah.
Okay, ma'am.
Yes, over to you. Yes.
Yes, ma'am. I think this will be the last question. Participant can drop question in the chat box. Let me read out one more question. US Supreme Court interpreted that the race can no longer be considered as a factor in university admission. India is still struggling for interpretation which are eligible caste for reservation. So I think interpretation affects with changing time and facts. What's your opinion in this?
About like my opinion, so that doesn't make it that doesn't make it a question of interpretation. But yes, it is, of course, when Dr. Garud has asked about this, so it's really important for us to understand. So I agree with you that interpretation changes with time and facts. So it's not or any region issue or any religion issue. But yes, all these issues really matter.
Thank you very much,
So
ma'am.
I think
Yes,
we
ma'am.
have completed all the questions.
Yes. I think we have taken all the questions. So thank you very much, ma'am, for your
Yeah.
precious time and explaining, giving insight on your
Yeah,
experience and
thank
topics
you.
how to teach. And now request
Yeah.
Gaurav to give a formal vote of thanks to ma'am. Over to you, Gaurav.
Thank you, sir. Thank you so much, ma'am, for giving us such wonderful and useful practical insights for the faculty members to understand and realize the different teaching strategies, tools, and nuances to teach this important subject of interpretation of statutes to law students. Ma'am, you beautifully simplified the thin line of difference between interpretation and construction of statutes, as well as the different objectives of interpretation of statutes. Ma'am, you discussed the different rules of interpretation and their relevance in the present times and how judiciary has played a vital role in resolving the ambiguities and conflicts in statutory provisions, due to which even more than 100 years old legislation of British times are still relevant and continuing even now. You also highlighted views of some of the famous jurists and how judiciary has utilized these tools in landmark judgments. Further, you discuss the relevance of obiter dictums of higher courts in present times and their impact on society. You also emphasized on different dimensions and related issues like the interrelation between law and politics, ideology of judges, etc. So once again, I would like to express my sincere thanks for this excellent, comprehensive and informative session. Thank you so much, ma'am. As we are heading towards this successful completion of this wonderful 1 month FDP program, I would like to heartily congratulate Dr. Kalpesh Kumar Gupta sir and his entire team for the immense efforts they have put in each session to make this maximum beneficial and meaningful, which was like a great intellectual tour or feast for all of us. Also, I would like to thank Dr. Kalpesh sir for providing me this opportunity to moderate some of these sessions. Lastly, I would like to thank all the participants for their patient listening, active support, participation, and interaction during the session from the last 1 month. Thank you.
Thank you very much, Gaurav. Thank you
Thank
very
you
much,
so
ma'am.
much.
Look forward to see you, ma'am. Thank you, ma'am.
Thank you.
Thank you, ma'am.